Good evening, everybody. Today we have the eminent jurist and senior advocate of the Supreme Court, Dr. Abhishek Singhvi. Dr. Abhishek Singhvi is a name that doesn't require any introduction. If we start counting the top 3 senior counsels of the country, his name stands out in the forefront. He also enjoys the distinction of being an eminent jurist. Dr. Singhvi has been a senior 3-term and sitting member of Rajya Sabha. He is a former chairman, Parliamentary Standing Committee on Law and Justice, India's youngest designated senior advocate at the age of 34. He also served as the youngest appointed additional Solicitor General at the age of 37 in the year 1997. He is a well-known author and columnist and a visible media personality. He is also the senior most serving national spokesperson of the Congress Party. He is also acclaimed as the author of 2 English books titled as Candid Corner and Straight Talk, both with forewords written by former Prime Minister Dr. Manmohan Singh. He is also an occasional columnist in major Hindi dailies like Dainik Bhaskar and Rajasthan Patrika. Awarded the Global Leader for Tomorrow by the World Economic Forum at Davos in 1999, Dr. Singhvi has been the opening lead speaker for the Treasury Congress benches in Parliament for almost every major debate from the year 2006 to 2013. He has been the common factor in almost all landmark Supreme Court cases spanning constitutional law, corporate law, arbitration, and several other subjects of importance. He supports many charities, including the Prayas Center for Destitute Children and the Singhvi Scholarship at Trinity College, Cambridge. This is apart from the sterling work done by him over 12 years in Rajasthan from his MP LED funds supporting 400 projects in the field of health and education. He is a former chairman, Indo-US Forum of Parliamentarians, having chaired a diverse delegation of 12 parliamentarians for 2 years to Yale University. He is also former president SARC Law, an apex NGO of judges, lawyers, law persons of the SARC region. He is former member governing body National Law Universities of Jodhpur and Delhi, and therefore I feel the student fraternity can very well connect to him, and that was the reason why we requested Dr. Singhvi to speak on a topic which may relate more to the student fraternity. Dr. Singhvi topped India at the school leaving Indian School Certificate Exam and did BA Economic Honours from St. Stephen's College, MA PhD from Trinity College, Cambridge. He also taught for a while at St. John's College, Cambridge, and went to Harvard, USA for a summer program. He was also ranked some years ago at number 34 amongst the India's top influentials by India Today Group in their annual power list. Our moderators today are Mr. Jaiveer Shergill. Mr. Jaiveer Shergill is an alumnus from West Bengal National University of Juridical Sciences and has further pursued his LLM at the UC Berkeley School of Law. In the year 2006, after graduating from law school, he enrolled with the Bar Council of Delhi High Court and began his career as a law associate with economic law practice. In the year 2008, he was accepted in the chambers of Dr. Abhishek Singhvi, since where he has been a practicing advocate at the Supreme Court of India. Our other moderator, who is also the EC member from our CAN Foundation, is Mr. Abhikal Pratap Singh, who is an alumnus of Dr. Ram Manohar Lohia National Law University and an advocate on record in the Supreme Court of India. Abhikal started his career with the chambers of Mr. Gaurav Agrawal, advocate on record, Supreme Court of India, from where he moved on to work under the tutelage of senior counsel Mr. Shekhar Nafde. In the year 2018 and 19, he has participated extensively in various international arbitration competitions in the global rounds of FDI arbitration moot courts held at Stockholm, Sweden, Miami School of Law. With this introductory note, I would like the moderators to take on the session. Thank you.
Thank you, Siddharth, for the introductions. And for the young viewers, law students, Siddharth has given an illustrious introduction to Dr. Singhvi. But I would just like to say one line and a personal introduction to him. Having worked in his chamber for 3 years, a pass out young student who was accepted without any reference and recommendation in Dr. Singhvi's chamber. He is truly my Dronacharya in the profession. A lot of young students have a lot of misgivings about seniors, that they merely pick up files and run behind seniors. Seniors these days don't have time. But let me tell you, my young friends, Dr. Singhvi is one of the rare individuals, the rare species, if I may say, who not only handholds his juniors, teaches them the art to separate the wheat from the chaff, the art of reducing or deciphering a 1,000-page brief into a 2-page brief, the confidence to walk with him, to stand with him, interact with the briefing councils. So Dr. Singhvi treats his juniors as family members, trains them, teaches them. As a lawyer, and also my role as a politician in a political organization is inspiration from him. So taking this conversation further, it will be Ghor Kalyug if I say a Shishya is sitting here to question his guru. So I will term this a conversation, an interaction with Dr. Singhvi. So welcome on this interaction. So first question, everybody knows your first love before a practicing lawyer and as a politician is academics, your love for reading, writing numerous papers. So in your experience as a student of law in one of the most prestigious institutions in the world, what was a typical day like for you in those institutions where you studied?
Well, let me start by thanking each one of you, 3 of whom I've seen on the screen, Siddharth, Jaiveer and Abhishek, for a very generous introduction. Let me assure you that I don't deserve all the very kind and warm adjectives you've used for me. But it's been great hearing you all speak with such warmth, and thanks once more. I don't want to sound didactic or sermonizing at all to our young friends, of which I believe are many there. Having sat on many interview boards, I've constantly believed that the young people we interview are far brighter and smarter than the interviewers. But coming to Jaiveer's specific question, were it not for possibly family pressures who wanted me to come back, were it not for the fact that I happened to be the only male child amongst 3 brothers, and therefore the Singhvi clan perhaps might have lost the only male child to foreign shores, perhaps I would not have come back, because while I was doing my PhD, I had started teaching to supplement my income. And it gave me a lot of joy, because I'd been an outstanding student right through from school and college. And academia in Cambridge is a bit of a fairy tale town. It's far too removed from reality. And it's kind of insulated. Everything is right. So if you don't leave it within proximate time, you will end up never leaving it for the real world, and you'll pretty much become unfit for the real world. So though I enjoyed it very much, a typical day was tough there, because my typical days here are equally chaotic, but the typical day in academia was in a sense tough, because I did all the capacities available at Cambridge, which is done rarely, as an undergrad, as a postgrad, as a PhD. And in fact, towards the end, I got married and my eldest son was also born there. So to have seen university in Cambridge and college in Cambridge from every different perspective was itself a learning experience. And lastly, to answer Jaiveer's question pointedly, I think there were challenging moments. I remember one particular moment on a personal tone where, in Cambridge, the success rate for a PhD is only 50%. Of those who enroll at all complete the course. 50% leave it. And of the 50% who do complete, the average completion time is 6 years instead of the stipulated 3 years. So you have to work towards deadlines, and you have lots of insecurities and self-doubt, because you are made to believe by others outside the system that you're doing pretty much useless things. Doing a PhD in law is certainly not necessary for a vocational program. So you are under deadlines, you're working hard, and I did. I used to work very hard because I had to finish quickly. And a particular week in December, I had my father's heart operation, the birth of my elder son, and a deadline to finish a chapter all in the same week. So I got the keys to the Squire Law Library which is a very venerable old Victorian building, and looks like a ghost structure at night, to be solely allowed to use the entire library 24/7. So you do the library at night, visit London in the day, and look after my young child and wife in the evenings and finish that deadline. So those were tough times, but now in retrospect, they were a big learning curve.
If young friends, if ever a book on multitasking is written, its headline title will be Dr. Abhishek Singhvi. All the things he has shared with you, he does much more tougher and busier multitasking tasks than what he did in college, and I'm a testimony to that. So along with being a practitioner, you're also a contributor in the public policy sphere. So seeing your contributions to the Indian political discourse, do you feel the disciplines like public policy should be taught with more emphasis in Indian law universities or schools?
One sentence on the previous point you made before I answer your question, I forgot to add. When I came back, I found that my yearning for academia could not be very easily fulfilled in the Indian system, which is something I think we should reform. The Indian academic system is far too rigid. It doesn't permit practitioners to teach. Now it is much easier and more flexible. In my times, if you wanted to teach, you had to go through a maze of bureaucratic procedures. And I think that interface between the teacher and the practitioner, which is so nice and flexible in England, for example, most of our teachers were also part-time practitioners, should be encouraged and expanded in India, which was then sorely missing and even today is imperfect. To your specific question, I think you're absolutely right. We are not really taught polity in the sense it should be. So if I say teach politics, in college and universities, you have the PPE course, politics and economics and things like that, philosophy, politics, and economics. In schools, I don't see why you're not taught politics. And when I say politics, I don't mean the politics you and I think of, the crass, crude version. But politics is about systems, structures, rules, the polity. That will include all of what you call a civics class, but that's a very small segment of it. Constitutional ethos, civics, the political system, our political history, how independence was got. A mixture of that should be certainly taught, because you do not have respect for the Indian system, except in the crass sense of what you see in the newspapers as politics, unless you are taught that. For example, if you are taught the amazing story of how the Constituent Assembly sat for 3 years and made our constitution, your respect as students for the Indian system would increase tremendously. But you're just not taught that unless you take a graduate course after joining college.
Dr. Singhvi, amongst the law students who are pursuing the LLB degree or who have finished and are in fact working as associates, there is always this internal battle and two thought processes going on, that whether a master's degree really helps, one. Second, is master's degree only academia, does not translate in something into concrete when you go to seek a job. So relating to that, your experience of studying at Trinity, at Howard, could you please elaborate on how a master's program abroad differs from the ones in India in their pedagogy? And if you contrast the same with your experience in India, and is it beneficial for our young students to pursue a master's program?
Well, I think my answer will contradict conventional wisdom. Conventional wisdom, which is largely right, is that law, like for example, medicine, architecture, engineering, etc., are vocational pursuits where academia is of limited help. So as the Indian culture also dictates, your parents and your elders will harangue you. Why the hell don't you leave everything and join the profession as early as you can? And that is largely right. You learn on your feet in the profession. But I have a different view, A, because of my personal experience. I did not only a master's, but an even more foolish thing, which is a PhD in law. Certainly, people will tell you it is a very foolish thing to do. But I think, A, people who are interested, young people, will never get this chance again before they join the rat race. And just for that very ground that you're joining a rat race, you should have this idea of the larger picture in academia. If you like it, if you have a passion for it, please pursue it before joining this profession. Two, in many cases, including mine, I think it gives you a presumptive aura of wisdom and erudition. It is only a presumption. It's a rebuttable presumption. You can falter by doing a few foolish things in your first days. But that presumption that you have some solidity and some worth as you enter the profession with a good set of degrees behind you does add, provided you don't, as I said, mess it up in the first 3 or 4 cases. Thirdly, I think today, especially with so much of specialization, in our days there was not that much, but today, you don't do IPR. Anybody says you do IPR, you start laughing. You say you do patents, you do Design Act, you do copyright, or sports law, not entertainment law only. So with this kind of specialization, I think that's another reason, a third reason why you should consider, if you have the time, if you have the resources, and if you have the interest, above all is interest, to pursue that. And don't think it's a waste of time.
I'll hand over to my younger friend Abhikal to ask a few questions.
Thank you, Jaiveer sir. Good evening, Singhvi sir. My query is, sir, in legal education, if we see in India, particularly if I talk about India, we see that there is a lack of synchronization between the practical application of law and what is taught in the legal curriculum in the universities. Sir, because you have, Siddharth sir has mentioned that you have taught in the university in your early days. Sir, being a teacher of your eminence, how do you think that this bridge can be curtailed?
Well, it's partly the point I made earlier. I think the Indian system, even today and much more so in my time, though it's much better from then, remains inflexible, both in our professions and in academia, and especially in academia. When I came back, I had this great urge to teach and practice law. You run into rules and regulations. You have to take so many classes. You have to take it at so-and-so time. You have to take it on so-and-so days of the week. There is no flexibility. So those who are interested, good, or genuinely knowledgeable about that subject may well get lost out. Whereas those who merely have a degree but conform to the bureaucratic limitations of the system, they will qualify. I think that's the biggest negative in our system. But 2, remember that some of the best and brightest teachers abroad are from India. It is not the talent, the human talent. We have the best and brightest in almost every sphere. The problem is that talent is not allowed to flourish in the correct ambience. It's an absence of ambience. Ambience means freedom to innovate, to strike a new direction. Here, innovation is penalized. Freedom to speak, to question. I think these are things, and wherever you have achieved it, you've got cutting-edge institutions in India as well. Wherever you have partially or fully achieved these values, you will find they are the top of the world class. The IIMs, some of the IITs, some of the new business schools, etc. So it's very clearly we know what is to be done.
Thank you, sir. Sir, my next query is, if we talk about alternative dispute resolution, sir, this process has, recently, if we see, sir, it has been a much sought after discipline of law. Sir, in your opinion, how can the educators, while in college, they can design a robust curriculum to bridge the gap between the theoretical and the practical aspect of law?
ADR is today 100 times more important than when I joined. And let me tell you, 10 years later, when your generation is coming up and the generation after that, ADR will be the mantra of the moment. Let me share with you, number one, in the 90s, I was privileged to be, early 90s, to be part of a project which Justice Ahmadi started. But this, of course, Supreme Court focus, which ultimately our report, which is a mixture of Indian and US judges, we studied the Californian system. California is the origin of ADR. And I'm proud that a report largely authored by me in that group of 6 people became the basis of the enactment of Section 89 of the CPC. Today, Section 89 of the CPC provides you with a menu card of ADR options. Lok Adalat, conciliation, mediation, arbitration, blah, blah. Now, this menu we studied statistically and otherwise from California and suggested there is a major option here missed out in India because it's not possible. But in California, we found from our studies that the most successful form of alternative dispute resolution was by judicial settlement. a sixth option, not in 89. Judicial settlement is ADR by a sitting judge. Now, a sitting judge somehow evokes so much respect and trust that the maximum statistical success rate of ADRs in California was found by sitting judges. Of course, the sitting judge could not be the trial judge. He had to be somebody else. So, but that we cannot have here because we have such pendency, such shortage of judges, such vacancies. But therefore, ADR is something with which I started my career. I've written a lot about it. 89 is a product of our labors. And it is a bit of a tragic thing that even today in 2020, I do not find in India what I found on my Californian travels in 1993 and 4. Chambers of lawyers, I remember in California, called JAMS. A law firm which is JAMS, Judicial and Arbitration Mediation Services. Today, it is very, very limited way starting. But do you have any law firm in India which says we are an arbitration, conciliation, and mediation law firm only? You just don't, because that culture. And this is going to happen. It is happening in a small way, but it will happen bigger way. We have excellent court-annexed arbitration in the high courts, which is one of our suggestions in that report. We have a lot of disposal in Supreme Court, but we will take it to the district courts. We will take it down to the lower courts. Court-annexed arbitration by trained people. People think mediation and conciliation is an informal, casual thing. Trained people, and lots of youngsters are going into it. I think we need to expand it, and that's, as I said, the mantra for tomorrow.
Thank you so much, sir, for such valuable insight. Now, Jaiveer sir will address the next query.
Dr. Singhvi, legal education in India saw a tectonic shift in terms of structure when the traditional 6-year span, 3 years after the basic graduation, was integrated into a 5-year law school program, with Dr. Madhav Menon starting the first one in 90s in Bangalore. So do you think, what are your thoughts on the 5-year integrated program, A? B, has it achieved the purpose of being more structured, bringing more people in a streamlined fashion into where you don't need a godfather in the profession? So what are your thoughts on the program and its productivity and what it has achieved?
I think very clearly that it's a very necessary and outstanding achievement to have the 5-year program along with institutions of excellence, many of them known as the national law schools. I think there are lots of valid criticisms. Everything is not hunky-dory, but we have to see the glass 75% full while we recognize the glass 25% empty. I don't think we can write it off, number one. Number two, what the position of legal education was when Ramakrishna Hegde gave a land for the National Law School in Bangalore, and what it is today is a sea change. I have had the privilege of serving on boards of places like National Law School Delhi and also my hometown Jodhpur, where in fact we fought and got it there instead of Kota, where it was going. It was an intra-Rajasthan fight. But these are all institutions, the one where you studied, National Law School Kolkata. They may have lots of teething problems. They have lots of scope for improvement. I can go into those details. But compared to the schools we had before them, I think they are still islands of excellence. My second point is, it's precisely this. We have to convert it from being islands of excellence into at least multiple islands of excellence. You have to increase their quantum. Today, at the end of the day, they cover a very small fragment of the student population. And third, I think the biggest thing is, which I've written about, we need to have a law school to produce law teachers. Today, the biggest problem is you have no law teachers being produced. You can keep on duplicating national law schools. You can even have very bright students joining. You can have islands of excellence made into multiple islands of excellence. But unless and until you have good law teachers, what will you do? Now, law teachers are going, rightly I say, I don't blame them, potential law teachers are going into corporate law practice, litigation, solicitors, direct practice. Now, nobody expects a law teacher to earn as much as a practicing lawyer. But the simple answer is that you have to at least halve the gap or make the gap from a ratio of 10:1 or maybe 50:1, make it at least 5:1. A man will take a hit of 1/5, but still there should be some nexus. You cannot expect a bright young chap to devote his life to teaching. And that is why today you find that the national law schools are hunting around and begging for directors and heads. The same person gets rotated. I do National Law School 1 and then I go to National Law School 2, Then I go to National Law School 3 as a director, because there are so few of them. The same names, I used to joke with my friends, they're the usual suspects.
Dr. Singhvi, in fact, my next question is related to the comment you made about earning, that a teacher does not earn well. As young 5-year law students, from day one, when you have to choose your internships, you are drawn to this misconception that a corporate lawyer has a more predictable career than a litigating lawyer. Corporate law is more, the returns are higher, salary package is higher, and litigation doesn't give you that predictability. So young lawyers often end up taking corporate practices over litigation because of the promise of quick success and money, if I use that term. The craft of litigation has seen a continuous drop in fresh graduates pursuing it for the same reason. How should this mentality be addressed? And if I may add, even when the law firms come on campus for recruitment, the recruitment is much higher within the corporate department of a particular law firm than the litigation law firm.
Look, these are first and foremost matters of personal predilection. You have to go where your heart takes you, which you enjoy. And for that purpose, you can try out both. And you may think that you like corporate, you get sick and tired of it. I came back from abroad fascinated by the idea of joining excise law. I thought it's the best area to join. So I asked for who's the best in excise, and I joined in as soon as I finished my law education. And I got so sick and tired of it that I left after 3 months. So this has to be first and foremost your own life. Second, I think there is bound to be some sense of security. And I don't think you can take away that sense of security in a corporate chamber or fixed job. Everybody is not similarly placed, and the sense of insecurity and the sense of security have to be counterbalanced. And I think to that extent, you should not grudge a person his predilection. 3, I have now found that on the contrary, a large number of movement and migration has started from corporate and chamber lawyering to litigation. You'll be surprised how many are joining litigation after having spent almost 8 years. Fourthly, I think there is one interesting statistic missed out here. There is no doubt that economic-wise, security-wise, stability-wise, the first 10 years, the job of a litigator is very much more insecure, possibly 15. But even an averagely successful litigator, both economically and stability-wise, starts outstripping his batchmate counterpart in the corporate and the chamber field after, let us say, 15th year. That's a realization coming up. So if you have the resources to last out the first 15 years, litigation is now becoming the preferred destination. And I know of some established people who have come to me whom I've asked, why the hell did you leave your such a good, virtually partner level? I'm not talking of partner level. And they would say, no, we find that the excitement of litigation is something which we want to go for. So I think this will keep on happening. But to answer your question as to what we can do, I think the best we can do is to provide institutionalized, structured placements. Today it is chaotic. I can join you because I know your father's uncle's sister. And tomorrow somebody else cannot join because he comes, he's a bright guy from some Raipur University where nobody knows about it. I think we need to make it structured. We need to formalize it. And we need to make it non-optional, non-volitional, much more than it is today.
I would like to share with our young friends, once Dr. Singhvi and I were having a conversation over lunch, a light-hearted conversation where he used to analyze his post-lunch court scenario. And I asked him, sir, what is it that drives you? Is it the money, the fame, and what makes a person successful? And he looked at me, he said, is the fire in the belly for having an identity. It was a summer afternoon. And that fire in the belly is what made him the youngest senior advocate in the country. And if I may quote one shairi which describes Dr. Singhvi's early success, कि ये यूं ज़मीन पे बैठ के क्यों आसमां देखता है, पंख खोल ज़माना सिर्फ उड़ान देखता है, लहरों की तो फितरत होती है फड़फड़ाने की, मंजिल उसी की होती है जो अपनी खुद की आंखों में तूफान देखता है. Dr. Singhvi saw that tufan and became the youngest senior advocate. So, any tips for those who are in litigation, interested in litigation? What is the path to be taken for success, though I may doubts anybody can break your record to be the youngest senior advocate.
It's very kind to use such superlatives, but let me tell you, there are lots of substitutes for everything. As they say, there is a substitute for Harvard. There is a substitute for what there is no substitute for, including the answer to your question, is hard work. There is a substitute for Harvard, but not for hard work. If you are a litigator at whatever level, and being a law officer at 37 or a senior advocate at 34, it's like being thrown into the deep end of a pool. So you find that the only thing which saves you from drowning is A, the strength you have to flail your arms, and some degree of strokes which you may have learned. There is the best friend of a litigator is the number of hours he has spent on that small little file which he calls a brief. And the confidence which it gives you once you are well prepared is underestimated by lots of my young friends. They believe that it's face value. They believe that it is browbeating by the other side. They believe that there is pressure from the judges. They believe that there is leg pulling by the client behind you. Yes, there is all of that. But the best antidote vaccine for that is a well-prepared brief, because the confidence it gives you that you know it better than everybody else around you. And that is the only thing when you are alone in the pool at the deep end. There is no father, no mother, no senior, no junior. You have to get up, and that's the difference between litigation, which essentially at the core is non-delegable. So if it's non-delegable, it's between you and your soul. And that comes only from knowing the brief inside out.
Vikalp, I'll hand over to you to ask him the next few questions.
Thank you, sir. Sir, Singhvi sir, my next query is, sir, in the course of a lawyer's career, we often come across and we often see there's a conflict between personal and professional work. Sir, how did you personally tackle these situations, and what would your advice be on the same?
If you restrict it to personal, you'd be surprised. I did not find as much conflict as I'd anticipated. I would say, if you talk of just personal conflict versus a brief which I get, it might not even be 5 or 10 times in my entire career that I had a hesitation. Remember, I'm making a distinction between personal and some of the public hats. That may be a different situation. But, I think two things here are important for your viewers to understand. One, you have to realize that a litigator, or a lawyer for that matter, does a very difficult task because he's simultaneously discharging 2 or 3 duties. His first duty is to his client, and the most important component of the duty is to speak fearlessly and present his client's case in the best possible light. It's surprising how much of the world out there is neither black nor white. It is actually large shades of gray. People tend to think it's a black or a white. And the reason why lawyers are necessary and successful is because they know how to highlight the best part of those shades of gray. Second duty is to the court. A court, especially to a litigator, will not take you seriously unless you discharge your duty of fairness to the court. If the court has to second guess each page you refer to, or every fact which Jaiveer says has to be second guessed because the court thinks that Jaiveer is unreliable, then Jaiveer will never make it. So that duty of fairness and trust comes over time when courts start trusting you that you say the straight thing, the right thing. The third is your duty to society at large also, which means that you have to ensure your job is done by the first 2 duties, but without any sharp practices. A sharp practice means that you cannot win at any cost, you cannot start forging or manipulating things, etc. Now, these are 3 simultaneous duties, seemingly contradictory, which is not easy to fulfill. However, if you are aware of them, I think your conflicts will be minimized. And also, as a professional, I follow the principle that lawyers do not choose their clients, 99%. And lawyers, therefore, also cannot judge their clients. And I end this point by saying that if you will start judging your clients, which is part of your question about professional and personal conflict, I mean, another form of asking the question by a layman is, what happens when somebody comes to you whom you are sure is a murderer? Now that question itself is flawed. I cannot be sure that you are a murderer because I'm not the judge. I don't choose you, but I also don't judge you. I do judge you in my mind, but I keep that in the recess of my mind. That's why I'm a professional. You know, people forget that there were 3 Sikh gentlemen who were convicted of Indira Gandhi's murder. In 84, 31st October, I doubt if there was a single human being on planet Earth who thought that any of those Sikhs was innocent. All 3 were convicted, all 3 got a death sentence by the trial court. The High Court convicted and upheld for 2, converted 1 into life imprisonment. The Supreme Court acquitted 1, maintained life in the other, and convicted with death sentence the 3rd. Now, do you think that chap who got acquitted had any chance if every lawyer, in that case Ram Jethmalani, thought that he's so bad and so guilty that he would not even take his case? Possibly, I would say that Ram, who had been a good friend of mine, had his doubts. But if he allowed those doubts to transfer, to predominate his legal instincts as a professional, then I think he was failing his duty by his client, the first duty I mentioned. So you have to train yourself to minimize your contact.
Thank you so much, sir. Sir, my next query is, sir, could you elaborate on the lessons you imbibed from your esteemed father, late Shri L.M. Singhvi, in the early years of career? Because, sir, he was so prominent, he was so influential. Did it make any impact on the choices you made in the early years?
Well, it's, I think, a great blessing to have a multifaceted person like that as a father. It's also a bit of a scourge. My father, I reconciled rather late to the fact that, you know, there is always, strangely somewhere, a competition between father and son. I think in different degrees it is there in all of us. And the sooner you realize the truth of that, the better you are off. I realized rather late that I could even totally compete with my father because of the sheer versatility. Apart from anything else, I may be very good in something, but he was a very versatile individual. So Sanskrit conversation to composition of Hindi poetry to giving an extempore lecture in Hindi on philosophy, etc. His range was very wide. So I stopped competing very shortly with him, but I think he was a tremendous role model, great inspiration. And possibly subconsciously the fact that I did academia, the fact that I was a good student, I wanted to pursue PhD, by the way, contrary to his advice. He had done his PhD from Cornell, his LLM from Harvard, and yet he said, this might be a waste of time, don't do PhD. So contrary to common misconception, I did my PhD because of my mother, not my father. But yes, it gave me a fillip for excellence. It also, he was my legal guru. I joined him because I found that the only 3 other people I wanted to join had full chambers at that time. So the first 3 years of my life, I practiced with him. I learned about felicity of expression from him. I learned about precision from him. So there are lots of role model things which happen. And I think, but you know, you soon get into an equilibrium with your father, and that's best when you do. And later on in public, we were in different formations completely. And but yet we were very close till the end.
Thank you, sir. I'll request Jaiveer sir to take it over now.
Dr. Singhvi, you use the word the usual suspects for law schools. Even now when it comes to seniors advocates, there are usual suspects, especially in the Supreme Court and the given high courts, which leaves the young lawyers who are looking to work or find good seniors to intern or be in their chambers very confused. And you, in one of your interviews after coming back to India from your education, you said in the initial years you found it very difficult. You found difficulty in finding a good senior to work with. What do you feel about the current scenario? What should be the parameters? Though it, as I again said, will be a Kalyug example for any say that I will choose my senior. It should be the other way around. But what should be the criteria? And is it still difficult to find a good senior to work with?
Well, I think you have to realize that India is in every sector, many Indias in one. the quality, we have the best and brightest in terms of lawyering and judges in India, the best and brightest globally. But obviously, the quality of a lawyer in place X in court X versus the quality of a lawyer in place Y in place court Y is vastly different. So first thing is many Indias in one. There is a lot of disparity, which more so than any other country, where there is greater homogeneity. We don't have that degree of homogeneity here as we have in US and UK. Second, therefore, choice becomes important, and the youngsters of today should not go by mere age and designation, because obviously in the country as a whole, for a variety of reasons, the appellate, the appellation senior advocate can be attached to many people. But if you look closely, the ones who command a large practice at the bar, there will always be, of course, a lot of flaws in each one of them, but there will always be one or two qualities which have made them reach where they are, if you see carefully. And so the person has to respect that, and the person has to identify that. Number three, having done that, you will find a fairly small pool. In the Supreme Court, you can count it on, twice over in your hand, in the fingers of the hand probably. In the High Courts, also the same thing. So I think you have to then just try your luck with them. And let me assure my young friends that today, yes, there is a lot of things like personal recommendation, relations, etc. But today in 2020, the legal profession is at least 20 times more a meritocracy than it was when we were there. And when we entered, it was possibly 10 to 15 times more a meritocracy than when my father entered. So merit is increasingly being recognized. And if you really work hard, if you want to go ahead, if you pursue a passion and do those three duties with a certain degree of strength and fairness, I think you should have no self-doubt, you will succeed. Yes, the problem is that the placements in very good seniors chambers are limited. There are far too many people. It happened with me myself. I joined my father after very clearly having decided never to join my father. And he was not very keen that I joined him, but I found that, I won't take names, but the 2 or 3 top seniors at that time, the chambers were full. There were 3 or 4 of them, major counsel with them. And I said, no point just being an add-on. So that is a problem. So you have to, try your luck and wait it out, and then just, find whichever slot you can best get.
Dr. Singhvi, because especially you came in that time, with the advent of globalization, opening of markets, a lot of new laws were developed to catch up with the changing times, and a lot of laws saw disruptions also. A lot of industries saw disruptions. And one of those laws is telecommunication law, in which you have practically been instrumental in shaping the telecommunication law. So please could you share your experience in the area of telecommunications law, especially your role in major 2 and 3 cases in the past years?
I think barring the last few years when Jio came in, and I took a retainer from Jio, which made me not appear as widely for every other player in the market, because Jio has become dominant and fights for everyone else. I am proud to say that when the Act first came in late 90s, if I remember right, the Act is 97 or 96 end of 97. Right from then, I had the privilege of doing virtually every important telecommunication matter. And it started with the High Court. And I remember the young lawyer, Justice Usha Mehra, and she pointed out that consultation was a prerequisite before making a recommendation. And that led to a change, an amendment to Section 11. Right from that case onwards, the entire WLL, imbroglio, and multiple levels, it would be basically TD-SAT and up to Supreme Court and back on remand and back to. So it's been a fascinating learning curve. This was an area from 97, which is a pure learning curve for me. All the technology, all the technical terms, the approach to the Act. Now, of course, TRAI is a very well-known, now you are looking at new regulators. But in those days, this was the cutting-edge new thing. And I have fought governments for the association. The COAI used to be the association, is the association for all cellular operators, against the government, many famous battles, up to the Supreme Court. I have fought intra-operator battles between operator A and B versus C or vice versa. And I think it's still an evolving field. Of course, now things have stabilized more, because in those days, every part of the act was being decided. And now the case law is not so, but today it's developing in different areas. For example, in a recent case arising from the Competition Act, where telecom and competition was intersecting. So these are now the new areas. But let me conclude by saying it was a fascinating learning experience. B, possibly nobody's had such a continuous association with one sector as I have had. In fact, the Economic Times did an article tracing my appearance in several major cases. And thirdly, I think this was one of the very important moolah sectors, to put it crudely, for a young lawyer looking for sustenance. Telecom managed to sustain me fairly well in my younger years.
Dr. Singhvi, it has been printed in many interviews and in your televised interviews also. You often say politics and law are your two jealous mistresses, if I'm quoting you right. And there is one demanding more time than other, but there is, as in any love triangle, you have to sometimes make hard choices. So in your line of practice, you had to take cases which are against the government of the party you represent or against the party line. So as an officer of the court, as a professional, as a politician, how do you deal with it and resolve that conflict?
I just answered Avikal's question about personal and professional, and I think that part of the conflict was very easily resolved. But this part, wrongly, I think, creates bigger problems. I have personally, and a lot of others, of course, as I say always, multitasking is the joy of my life, and multitasking is also the bane of my life. I've had the privilege of having options and choices to be able to multitask, and that itself is, I think, a blessing. But sometimes it creates a lot of tension and pressure, and is not very good for health. Having said that, all the three areas where I have to spend a lot of time, law, courts, the parliament, and the party work, are within 1 kilometer of each other, and therefore that makes life a little easier. But in that sense, I've been privileged to be, in some sense or the other, a part of the executive, the judiciary, and the legislature, loosely so called. Having said that, I think times have changed. Robustness, openness, transparency, and most importantly, the media has changed. And this is a very serious answer to a very serious question. According to me, there is no conflict if I, as a supposedly good lawyer, appear for a top BJP. When your tooth aches, you don't go to a dentist according to the political color he wears. You go to somebody whom you think is a good dentist, damn his political color. That used to be, to a large extent, our culture till the 80s, 70s and 80s. Today, media has gone into every part of our world. And today, there are screaming headlines that, oh, I am appearing for Jaiveer Shergill, opposite political colors, which means I have, I am a Dalbadli, I have completely changed my colors, I am in collusion, I am in conspiracy, and vice versa. There was a time till not about 50, 20 years ago where I appeared for lots of people with legal problems of opposite political colors, including BJP. You see, do you think that solid people are so saleable and so lightweights that they will be affected by these professional engagements? That's a mistake. But I think that is now the price we pay for irresponsible, screaming, sensationalizing, salacious media. The media's job is to do that. It has to draw motives. So if I appear, suppose Mr. Shergill here belonged to a party other than mine, and he had a genuine legal, when I appeared for him purely, obviously, I cannot appear for him where it directly cuts the interest of my party. But if he has another problem, normal property dispute or something, why can't I appear for him? Do you think that I'm conspiring with him if I appear for him? But that culture has changed, and I regret it. And lastly, to answer, I have, in fact, now maintained a list over the years of at least 200 cases where I've just refused the brief. Very, very major. Some of the names you've seen all over, your top names, headline cases, which I've refused on perceived grounds of conflicts of interest to a political affiliation I have. That's not the way it should be. Even today, I find ill-informed criticism and comment in the press that so-and-so is appearing for so-and-so crook. अरे भाई, अगर वकील so-called crook के लिए appear नहीं होगा, तो कौन होगा? And do you think that it affects the political color of that? It should not. But unfortunately, the reality, and therefore the answer to Jaiveer's question is, yes, it does. And today that conflict is much bigger than the earlier one, which Abhishek asked about personal and professional.
Abhishek?
So, sir, as a third-term member of Parliament, does your experience testify that there is a gap between the legislature and the judiciary? And if yes, how do we bridge that gap?
There is obviously a lot of trust deficit. I'll give you an example. Whenever there is a debate in Parliament, and I'm now into my 13th year, by the time I leave it will be 18 years in Parliament, on judges, judiciary, or legislation proposed to supposedly control the power of judges. Take, for example, the National Judicial Commission Act. It will have cross-party support, and the voting in that case was 99.99%, except for one or two people everybody voted for it across party lines. Because each of these organs looks with suspicion and distrust at the other. And the legislators, because they feel that they are policed, chastised, controlled, scolded, punished by the judiciary, and frequently they think that they are done wrongly this by the judiciary exceeding its powers. Therefore, you have this trust deficit. However, I think it is also a lot of ill-informed criticism in the legislatures equally. There are knee-jerk reactions. They don't understand the way the judicial system functions before they criticize it. So I think it's traffic both ways equally. There are irresponsible comments by judges sometimes, fortunately a very strong minority. There are irresponsible approaches in cases where blatant judicial power is blatantly exceeded. So I think these are the transgressions, and we all know individual cases, I'll not mention them, where that should be the consciousness that, see, ultimately the Constitution is supreme. Ultimately, because the Constitution is supreme, judges will remain supreme because they say what the constitutional answer is, even if the Constitution doesn't say so. But because of that, they have to exercise restraint, because ultimately there are three wheels of this chariot.
Thank you, sir.
Dr. Singhvi,
Jaiveer, sir.
moving to a lighter conversation, there is obviously a tone of seriousness, and the courtroom atmosphere is serious. Could you please share with us interesting anecdotes from your interaction with various judges or seniors or contemporaries at the bar?
Sadly, I've always believed that I should be noting them down in a diary, so most of them are lost. B, I believe strongly even today that humor in court should be a rag sheet by putting young correspondents in every courtroom who collate the funny things which happen in court and feed a central system every evening, which is then brought out in a responsible way on a weekly or a fortnightly basis. A kind of Gustaki mass of a courtroom, because the kind of comments, the pronunciation, the action, the jokes which happen in outside court are remarkable. Having said that, and a whole world, I mean, having spent now decades in it, how much we have lost in terms of memory, I don't know. But some of those three things have happened in my presence, which are always very funny and remember. The incident with Kuldeep Singh, Justice Kuldeep Singh sitting in court too, when G. Ramaswamy, both Ramaswamy and Kuldeep Singh were colleague additional Solicitor Generals together. And Justice Kuldeep Singh was also a very loud-spoken, aggressive kind of judge who loved to be speaking from his heart. Like a true Sikh, he would speak out and never restrained himself. And G. Ramaswamy, for all his other foibles, was a man with great ready wit of a very earthy kind. And he made a proposition to Justice Kuldeep Singh, at which Justice Kuldeep Singh said, how can you say this, Mr. Ramaswamy? Do you think we are fools? And I remember, pat came the reply from Ramaswamy without hesitation. He said, sir, if I say yes, I'm guilty of contempt. If I say no, I'm guilty of perjury. And for a full minute, for a full 15 seconds, there was silence. And when the thing sank in, Justice Kuldeep Singh burst out laughing. Now, this is both ready wit and large-heartedness simultaneously. In fact, Ramaswamy had that a lot. He would joke with everybody when walking down the corridor and tell me, look, Abhishek, you see all these people in the corridor who are wishing you well. You should know that they're not wishing you well. They're wishing you in the well. And things like that. So these keep happening all the time in court. And I think it's a treasure house of anecdotes, of witticisms, but a lot of them are lost unless they're collected from individuals.
Dr. Singhvi, during the, especially from as they say that courtroom and reality of law is very different from what is shown in the movies. Similarly, the reality of how procedurally justice moves at a snail's pace is different from what is the essence of justice is taught in the law schools. Recently, in his farewell speech, Justice Deepak Gupta made a remark looking at some preferential listing or not listing of some important cases in comparison to others, that now earlier justice delayed was denied. Now even listing is becoming a matter of privilege in the Supreme Court. How do you see that comment?
First of all, reforms in the administration of justice, specifically beating the black clock or battle of the bulge, is my special area of interest, on which I've written for 20 years. Number two, Palkiwala said that the pace of litigation in India would be considered unduly slow in a community of snails. He said that, if India was to enter litigation and delays in litigation as a subject in the Olympics, it would win a gold medal every time. So the scourge of our system, which is otherwise fantastic, such bright judges and lawyers, avant-garde doctrines, we invented PIL, we invented basic structure of the Constitution. Imagine a remarkable doctrine which says a constitutional amendment is itself unconstitutional. We invented the degree and breadth of judicial review, which would make Marbury and Madison in US look like nothing today, etc., etc. And on the other hand, the only scourge we have is this backlog and delay. And there are very simple 4 or 5 things we should do and can do which should solve it. But this is not the time to enumerate it. Now, along with this system, I would endorse Justice Gupta's comment that what is known as leapfrogging, and leapfrogging both intra-court and otherwise is something which must be stopped with a hard hand at the threshold. I think, unfortunately, to an extent, the judges themselves are culprits. The pressure to hear a supposedly urgent matter because 3 top senior counsel are mentioning and shouting at you has to be withstood. Senior counsel are paid to do it. They will make their point, but that doesn't necessarily make it urgent. But assuming it is urgent, our definitions and rules of urgency have to be redefined. There has to be a simple way of taking care of leapfrogging is a track of 50% of the court must be set aside. Say you have 35 judges in the Supreme Court, at least 15 of them should be sitting separate benches, dealing only with 10-year-old and 5. Only. If you have to leapfrog, let the other 15 judges of 7 benches deal with the current filings and the other urgent matters. Leapfrogging is also very often very demoralizing. It is very discriminatory. It is uncalled for, and I think there is no cure for it except judges being conscious and uniformly, the operative word is uniform, dealing with it. Because what is happening is, today you, Mr. Avikalp, may be a strong judge who says no urgency, follow the queue. But a similar matter in another bench, Justice Shergill may say the opposite. And a 4th matter for Justice Singhvi will say the different thing. So uniformity has to be maintained, strictness has to be maintained, discipline has to be maintained. Can you hear me?
Yeah, I can. I think Jaiveer sir.
Yeah, Abhikal, can you hear me now? You can go ahead with your question.
Yes, thank you. Right, sir. Singhvi sir, you and late Shri Arun Jaitley ji You both of you sat at the opposite spectrum of the political scenario. Sir, could you describe your friendship or relationship with him? Because you've always called him a dear friend.
I think I was the only one who wrote 3 pieces within the first 2 days of his death in different newspapers about him. We had a lot of rivalry at one time, and yet friendship arising from professional respect. We were on opposite sides of the spectrum, but there was respect, and I think we have appeared opposite each other in the High Court in innumerable cases. We appeared on the same side. I've recounted several anecdotes and stories. It was common from the 2006 to 2012 period for both of us to be seen running around the Supreme Court. I don't know which year he became the leader of the opposition. Before that, running around the Supreme Court, doing 4-5 cases, and around 12:30 rushing there. From there to the Parliament. The opposition opens the debate. In those times, Congress was in power. So I would ask him, how long will it take to open the debate? So he said, you're safe for half an hour. So I do an extra and then rush and be the lead speaker to reply to him. So this has happened frequently. Partly the roles were reversed when he got into government, but he was nowhere a lawyer. And I would open the debate for the Congress when he was in power. But apart from that, I think we have shared canteen moments. We have shared so many other occasions. So I think he was in many ways a gentleman who respected certain. He would not do things in a crude fashion, and I think he took care of a lot of people who now stand by him. So I think these are qualities, and I think also a large-heartedness in politics, which I very strongly believe in. A large-heartedness in the bar, I strongly believe in, are matters which are now getting to be a casualty. And whenever we have those values, we must cherish them.
Thank you, sir. Sir, if we talk about the current scenario, currently, sir, we are seeing because of the COVID-19 pandemic, courts are conducting proceedings during video conferencing. Sir, could you give us or could you comment about the feasibility and the long-term impact of such courtroom or virtual courts on lawyering and as well as on adjudication?
You see, every crisis, every adversity has an opportunity. Every crisis has a scope for a lesson and reform. As somebody said, don't ever waste an adversity. That applies to COVID. One of the great good things about COVID is that we realize how we can use new technology. I have written an article where I have said that even when we come back to normal, which according to me will not be before August, as far as courts are concerned, because you don't expect hordes of lawyers descending on the Supreme Court or the High Court merely because you have a magical press down of a button saying lockdown is over. But even when you come to that stage, I have said you should have at least 33% hearings virtually. Why can't you make this? You cannot make it because of very silly small things. You don't have enough money, enough funds, enough capacity, enough internet. Lawyers are not objecting except a very small fractional amount. And imagine the efficiency, the lack of congestion, the lack of dirt, the lack of, kind of standing on each other's heads and shoulders inside congested courtrooms. So not that 100%, but it's the easiest thing to have normal court lawyering through virtual lawyering for at least 33%. I also believe that currently the Supreme Court is grossly underutilizing its strength. It's virtually doing like a vacation court. Had we got our technology act properly tied up, we could do many more cases. As a matter of fact, I've suggested in the article that 7 benches of 15 judges of the Supreme Court could have sat over the last 2 months, virtually heard cases for 2-3 hours, and dealt with only 10-year plus cases, which are a scourge on the fair name of the Supreme Court. Another 2 or 3 benches should have sat for the current filings. And I've said there in the article that the threshold for current filings, which are very difficult and high, should be maintained. That does take care of rightly what I call kachra filing. But still, you should utilize it fully. We function hardly 2 or 3 benches in a week, and this is gross underutilization, and that should be rectified.
Thank you, sir. Over to
Dr.
you, JB, sir.
Dr. Singhvi, the last question, and the question which, in my opinion, will be the favorite question of every law student and every person who aspires to be in a litigation chamber, and an inconvenient question for the senior advocate fraternity. The question is this: that as per a recent survey, Dr. Singhvi, 79% junior lawyers earn 10,000 rupees per month. 79%. And does a senior advocate not shy away from their responsibility to nurture the new entrants so as to raise the standard of payment in the bar, and thereby making litigation a feasible opportunity, especially if you pass out from these national law schools? You think there is a policy solution which can be found or pursued to mitigate the financial difficulties of the new entrants so that they can be encouraged to join litigation? And if I may say, why are we asking? There is a Hindi saying, "Mana paisa khuda nahi, par khuda ki kasam khuda se kam bhi nahi."
See, I think it's a very legitimate question. I welcome the question. The blunt answer is that I wish there was a policy or a legal solution. There is none. I think the rules are very simple. Only thing is they have to be followed in spirits. First, this thing about underpaid junior, now we're talking specifically of litigation. This
Yes.
is not true in chamber lawyering or solicitor firms where there's like a salaried paid employer. It comes from the old English concept that apprentices in fact come to learn and not to be paid at all. It's an old, quaint, romanticized notion. As a matter of fact, you'll be surprised. The Pythagoras conundrum, 2000 years old in Greece, starts with apprentice having to pay his teacher. It's the other way around. That's the old concept. So they expect that you will pay nothing as a litigator to your juniors. Number three, I totally disagree with this. I think that ultimately the equilibrium is found on this not by legislation and policy, because you can never police it. It has to come from the senior according to his stature in the profession. All seniors are not equal. Amongst the seniors, there are the top 5, then there are the top 10, then there's the top 20, and then there's the top 50, and then there's the top 100. Now, obviously, the paying capacity in the top 100 will not be the same as the paying capacity in the top 5. So I think any senior worth his name in the top 5 would be paying something far above that 79% average, which you have said. Equally, if you are functioning with a good senior, a competent person who's helping you at the bottom end of the 100, and maybe his paying capacity is not more than that figure, then I think you have to go into it with a learning spirit. But if your paying capacity is there and you are still paying 10,000, I think that is something which needs to be changed. The change, unfortunately, has to come from within the person himself. I can tell you this, that for many years, I have treated it virtually as an employment. It is certainly less than what you would get in corporate or chambers where you're employed. But then you must provide these youngsters with a fixed amount. Plus, if you can, involve them in 1 or 2 extra cases on the way, that helps. But at least a fixed minimal is vital. And this thing about having, and when the earlier than I started, I was taught that paying juniors is unheard of. You pay not even a stipend. So I think that culture must change. Seniors who are sensible have changed it. Ultimately, it's a matter of your own conscience.
I think I must put it on record for all the young viewers that Dr. Singhvi not only takes care well, I'm a testimony, well of his juniors commercially, but he also incentivizes hard work, where he, in his own way, gets involved you in cases, gets your fee fixed after weighing your work in the scales of how meticulous were you, how well researched you were you. So you learn a lesson that putting in a hard work will attract certain returns and revenues. So don't compromise on your work. So thank you for that, sir. I'll hand over to the organizers for the vote of thanks for your time.
Thank you. Thank you.
It was a very interesting and learning session. Thank you so much, sir, for giving us your valuable time. We are really grateful for this interactive session, sir. I would like to thank all the attendees for taking out time to attend this webinar. Before we sign off, I would like to also thank the student team of Ken Foundation, who have been very instrumental in organization of this seminar. Thank you so much, sir.
Thank you.
Thank
Sir.
you. I appreciate all your kind words. Thank you.